All right, good afternoon, everyone. I'm Erin Bryan, a partner in Dorsey's Finance and Restructuring Group, and I'd like to welcome you all to the second installment of our series on the recent bank failures of Silicon Valley Bank and Signature Bank. It's been an incredibly intense month in the world of banking, as you all know, and so we've reconvened today to reflect on the events of the last 30-some days and to preview what comes next. We've added a new speaker to our lineup, our colleague Tom Kelly, who will add a transactional perspective to our analysis. Next. Before we get started, there are a few housekeeping notes as usual. Our program today will be approximately 1 hour. The materials and attendance form are available to download from the reminder email sent to you from dorseyu@dorsey.com. If you'd like CLE credit, please send your completed attendance form to attendance@dorsey.com. We will not take Q&A today, but please do feel free to follow up with any of us afterward. And a CLE code will be announced for attendees in states that require a code. Next. Joining me today is Joe Liniak, a financial services partner in Dorsey & Whitney's financial services practice. He is an expert in the area of FDIC receivership and conservatorship law, including failing and failed bank issues. Also joining me today is Tom Kelly of Counsel and former co-chair of Dorsey's Finance and Restructuring Group. Tom has extensive experience in all forms of commercial finance, including leveraged acquisitions, asset-based financings, syndicated lending facilities, subordination agreements, purchases and sales of financial assets, and other credit-related transactions. Next slide. So the acute phase of the recent bank crisis appears to have passed for now. And Silicon Valley Bank and Signature Bank have both been resolved, which simply means that each of the failed banks has been acquired by another bank. So we'll start today by level setting on the current status of the bank failures. The situation is far less murky than when we last presented to you, but it is still quite complicated. Then we'll discuss how the FDIC receiverships for the two bridge banks will interact with First Citizens Bank and Trust Company and Flagstar Bank as acquiring banks and the obligations of those institutions. And finally, we'll discuss the authority of the FDIC as receiver for assets and liabilities remaining in the two receiverships and provide some insights on how this will play out. Next. All right, we encourage you to review our new Bank Failure Resource Center, where we've compiled helpful information and frequently requested materials regarding bank failures. On the website, you'll find links to Dorsey insights, media coverage, and external resources, including government press releases and comments. We will continue to update the Resource Center as the situation evolves. Next. So how did we get here? In 2021, SVB's deposits surged. They hit a peak in early 2022. However, over the later months of 2022, deposits began to decline by a total of 13%. This was largely in response to the Fed's increases in interest rates. Despite this, SVB still appeared healthy to most outside observers, including its own auditors. However, on March 8th of 2023, SVB announced that it would take a $1.8 billion loss after selling investments to cover the increased deposit withdrawals. It also announced a plan to sell stock to raise approximately $2.5 billion. And then that day, Moody's downgraded the bank's parent company, SVB Financial. The next day, the parent company's stock crashed and other banks began to follow. There was panic evidenced on social media as some high-profile venture capital firms directed their portfolio companies to pull deposits from SVB. This led to a classic run on the bank. Normally, regulators take control of a failing bank overnight, but that was not the case with SVB. On Friday, March 10th, trading of SVB shares was halted, and shortly thereafter, California and federal regulators announced they'd taken control. SVB became the second largest bank failure in U.S. history. As of the date of the bank's failure, SVB had $209 billion in total assets and approximately $175.4 billion in deposits. Over 90% of SVB's deposits were uninsured, meaning they were above the general FDIC insurance limit of $250,000. And because of this, for about 48 hours, customers of SVB were completely panicked about how to access funds and make plans to meet payroll. For those of us who were in the middle of this, it was utter chaos for a couple of days. Then on March 12th, however, when another bank, Signature, also failed, federal regulators announced emergency measures to protect all deposits at both SVB and Signature, and also announced a new lending program for banks. Next. For the next 2 weeks, the fate of SVB looked precarious. Ideally, the FDIC lines up a buyer before the public even knows a bank has failed, but that was not the case for SVB. Finally, on March 26th, the FDIC entered into a purchase and assumption agreement for certain deposits and assets of Silicon Valley Bridge Bank with First Citizens Bank and Trust Company. This was a lost share transaction, and Joe will discuss the implications of that in a few minutes. As part of the transaction, Silicon Valley Bridge Bank was placed into a receivership. And notably, the P&A does not include approximately $90 billion in securities and other assets, which remained in receivership for disposition by the FDIC. Next. So then going back to March 12th, this was the day that the FDIC also closed Signature Bank, a New York chartered bank. This happened on a Sunday, which was also unusual. As of December 31, 2022, Signature had assets of $110 billion and deposits of $88 billion. Approximately $10 billion in deposits were withdrawn in the days preceding the failure. In connection with the closure, the FDIC chartered a bridge bank, as it had with Signature or with SVB, to hold Signature's assets and deposits. And that entity was called Signature Bridge Bank. Next page. On March 20th, the FDIC entered into a purchase and assumption agreement for certain deposits and assets of Signature Bridge Bank with Flagstar Bank. As part of this transaction, Signature Bridge Bank was also placed into receivership. Next. I know that this audience appreciates why these bank failures were so alarming to regulators and the banking industry. The potential losses to businesses and individuals were staggering, and the implications for the U.S. economy and confidence in the banking sector were sobering. As of Sunday morning on March 12th, uninsured depositors at SVB and SB were at risk of loss in amounts exceeding $180 billion. On Sunday afternoon on March 12th, the FSOC members made a controversial announcement. The federal regulators invoked systemic risk as a basis to take emergency action under Title 12 of the U.S. Code, Section 1823, C4G, to guarantee uninsured deposits of SVB and Signature. Next. So it's April 12th now. It's been a full month, and here's where we're at. Regarding Signature, the FDIC has announced the proposed sale of the loan portfolio of Signature that had been retained by the receivership. This does not include any of the loans that were assumed by Flagstar. The FDIC, as receiver for both failed banks, announced the proposed sale of the securities portfolios retained in the two receiverships. The reported face values of the two securities portfolios are approximately $27 billion for Signature and $87 billion for SVB. The securities portfolios are comprised primarily of agency mortgage-backed securities, collateralized mortgage obligations, and commercial mortgage-backed securities. Next. So what did Flagstar get out of its deal for Signature? Flagstar acquired certain assets and liabilities of Signature Bank, which had previously been placed in Signature Bridge Bank. The transaction included the purchase of approximately $38.4 billion of Signature Bridge Bank's assets. This included loans of $12.9 billion being purchased at a discount of $2.7 billion. Approximately $60 billion in loans will remain in the receivership. In return, the FDIC received equity appreciation rights in New York Community Bank Corp. Inc. with a potential value of up to $300 million. Next. First Citizens, on the other hand, acquired certain assets and liabilities of SVB via the Bridge Bank. The transaction includes the purchase of approximately $72 billion of SVB Bridge Bank's assets at a discount of $16.5 billion. Approximately $90 billion in securities and other assets remain in the receivership for disposition by the FDIC. The FDIC received equity appreciation rates in New York Community Bank Corp. Inc. With a potential value of up to $300 million. And the FDIC received equity appreciation rates in First Citizens Bank shares with potential value of up to $500 million. Next. All right. There's been a lot of concern about who's paying for all of this. One way or another, I think we all understand that it's all of us. But as a technical matter, the FDIC estimates that the specific cost to the Deposit Insurance Fund of resolving SVB and Signature to be about $20 billion. As of December 31st of 2022, the Deposit Insurance Fund had $128.2 billion, or about 1.27% of all insured deposits. So the anticipated loss is really approximately 15.5% of the Deposit Insurance Fund. This also raises the question of what happens if the contagion spreads, despite all of the efforts of regulators and the largest banks to calm fears. Volatility and stress are widely expected to continue. And this raises the question of whether the Deposit Insurance Fund will be able to handle additional losses, and if so, how many. This could also come to a head sooner than later as we enter earnings season. Some customers of regional and community banks responded to the SVB and Signature failures by moving some of their deposits and banking relationships to other institutions. We'll soon have more insight into how this is affecting the bottom line of these institutions and how they plan to respond. And now I will turn it over to my partner, Joe Liniak, to talk about what comes next.
Oh, thank you very much, Erin. Just as a starting point, in the prior slide, there's a reference to a recent bank failures and the federal regulatory response. That was a report by the chairman of the FDIC to Congress, which is actually very, very helpful and lines up on a timeline basis what took place and what the FDIC did and the other regulators as a first step. As a second step today, the vice chairman of the FDIC, Travis Hill, added to the blame game by blaming everyone else except the FDIC and indicating what types of remedies might be considered. And those are things which interested parties may want to be looking at, particularly banks. I would suggest, however, that maybe what we should do is go back about 25 years and look at the autopsy reports for the S&L crisis, because in many ways this is a mirror image of what happened that caused the S&Ls to fail. Next slide. So now what's going to happen? Well, in the past, when the FDIC would close down a bank, and I think we talked about this in the last webinar, it takes about 90 days to be able to do it. It takes a lot of work, a lot of back office work behind the curtains. And the FDIC had to move extraordinarily fast in order to be able to resolve these bridge banks because they were starting from ground zero with no preparation. Erin mentioned that there's a purchase and assumption agreement for both of the banks, for First Citizens and for Flagstar Bank. However, when you take a look at them, you will notice that a lot of data is missing, important data to be able to understand exactly what was transferred, what was held back, and also what has not been provided to the public, at least in the case of First Citizens, is the loss share agreement. The loss share agreement is the document between the FDIC and the First Citizens in which losses are shared between the parties, such as meaning loss share agreement, but it's critical for purposes of determining the profit or loss you get on the part of an acquiring institution We've actually filed an FOIA in order to get that, in order to be able to be better to advise our clients regarding some of those matters. Next slide. What we're going to look at over the next couple of minutes are significant purchase and assumption agreements. What assets were purchased by the acquiring banks, meaning Flagstar and First Citizens? What liabilities were assumed? What do the P&A agreements require the acquiring banks to do? And how do the P&As work with the FDIC receivership powers, allowing the FDIC to operate? And effectively, the FDIC receivership powers generally flow through the P&A. Next slide, please. In other words, the P&A agreements are the primary controlling documents that now relate to these two failed banks. They established a process by which the acquiring banks will operate the banks. As of a defined closing date in the P&A agreements, a closing balance sheet is prepared, and it's an important balance sheet because it talks about the relationship between the FDIC and the acquiring bank. And in the case of a loss share agreement, is critical for purposes of determining, as assets get resolved and are not worked through just on a regular basis, who's got to pay whom, and usually it's the FDIC paying the acquiring bank. And it also involves the process, as I mentioned before, for the FDIC to exercise its receivership powers. When the bridge banks were in existence for those few days, the FDIC exercised receivership powers directly, and now they're going to be funneling through the acquired institutions. Next slide, please. In order to understand this, I think it's probable that perhaps you look at and consider this to be a tale of two cities. If specific assets and liabilities were transferred to the acquiring banks, for the almost most part, we're going to have business as usual, and we can all breathe a sigh of relief. And there's some issues here which we're going to have to talk about, and they're important issues. But as time goes on, business as usual. If specific assets and liabilities were not transferred to the acquiring bank, or were transferred and then sent back to from the acquiring bank to the receivership, it's an entirely different story. Borrowing from Dante, what it means is Virgil appears to you and says, "Benvenuti a quarto anello dell'inferno." Welcome to the fifth ring of hell, because that's what you're going to be experiencing, because you're now under the snatches of the FDIC. A few caveats. The actual liabilities and assets transferred by the acquiring banks have not been identified in the P&As. And so we're going to be struggling over the next probably 6 months to identify where things have ended up, what their resting place has been. Need to remember that the FDIC receivership powers, which Tom is going to discuss, are extremely one-sided, favoring the FDIC. As a public policy, we want these bank assets to be resolved, get back into private party hands, and then move on. In that regard, also, when you're talking about what are the rights of the FDIC, there is a very, very small amount of case law that is reliable, and the FDIC has got a lot of flexibility in particular circumstances, such as new circumstances, to reinterpret what their policies and their operational procedures will be. There are some old policy statements, which Tom is going to discuss, but again, they go back to the S&L crisis for the most part. And if the FDIC as receiver does something that they shouldn't do and they make an error, the counterparty, meaning us, is extremely limited in its remedies. And you may file a claim against the FDIC, but you will receive not necessarily what you've asked for, but a receivership certificate that is suitable for framing. And that's something, again, Tom is going to discuss in terms of the chances of being able to get a recovery. Next slide, please. As a general matter, And except as set forth in the P&A, all assets and deposits in QFCs, qualified financial contracts, that are not retained by the receivership are acquired and assumed by the acquiring bank. And that's everything that the FDIC receiverships had in the two bridge banks. These calculations are put into the closing financial statement that I mentioned a moment ago, and are the basis for the loss share agreements and for the relationship between the FDIC and the underlying parties. Now, the acquiring banks have got a put authorization where they have assumed loans or other assets, but they can put them back to the receivership. And so it's not a static situation at the moment. At some point, right now, what they're doing is both the FDIC and the assuming banks are doing investigations and determining what do we keep and what do we want to send back to the other party. And so they can send many assets back or deposits back to the FDIC. However, if they begin to deal with, for the most part, loans and other assets, and actually deal with counterparties, that put authority ends up being negated as to that particular asset. Next slide, please. And again, while this is somewhat circular in nature, there is a laundry list in the P&A agreements of what is not assumed. And a lot of it has to deal with liabilities that the FDIC can exercise against insiders. And yet still there's a lot of categories of things which they do not, which are not sent over to the acquiring banks. Insurance policies under which the FDIC may file claims for malfeasance or misfeasance, claims which are held against officers and directors and institution affiliated parties with the failed banks. Categories of on a balance sheet, such as prepaid regulatory assessments, interest and tax receivables, loan loss reserves, leased and owned bank premises to the extent not specifically assumed by the acquiring banks, anything which has an environmental hazard on it, goodwill and other intangibles. Those things are going to be washed out of the financial statement that is created at the time of the acquiring bank acquires its assets. Criminal restitution orders, prepaid fees, other things which are not assumed. Any asset deemed essential to the receivership. Well, there's a matter of clarity there, but that means that they can keep whatever it is they want, and they've got the right to come down and take it after the fact. Prepaid accounts that the acquiring bank does not assume. Interestingly enough, third-party loan servicing agreements provided by the failed bank, those things are terminated as to the acquiring bank, and you have to deal with the FDIC in the receivership in terms of third-party servicing. Bankers' bank stock, certain real estate and real estate subsidiaries, all charge-offs, loans secured by collateral held by the as an asset retained by the receivership, and so forth. So anything dealing with that theoretically is difficult to manage or may present a claim against the acquiring bank can be sent up to the receivership and is held at the FDIC, and that's not acquired as a result of the P&A. Next slide, please. Now, we would think of deposits being assets on our part, but of course, in terms of banks, those deposits and so forth, they're considered to be liabilities. And the P&A agreements indicate that the acquiring banks take assumed deposits. And assumed deposits is a term, and it's attached to the to exhibits in the P&A agreements, which we do not have at this point. But as Aaron mentioned to you, there were a significant number of deposits which were kept by the FDIC receiverships, and they have stayed up there. And that's where most of the losses are going to be arising that the FDIC has to pay off. Indebtedness secured by perfected lien owed by the bank. In other words, they come back over to the assuming bank, and and where those are going to be honored. Ad valorem taxes, liabilities, and this is important for acceptances or commercial letters of credit, liabilities for standby letters of credit. And there was considerable concerns during the bridge banks as to whether or not those were going to be honored. And by the terms of the P&A agreements, they will be honored unless, of course, the assuming bank decides to send them up to the FDIC. And so we're going to have to wait and make sure that that doesn't happen. But if they begin to deal with you, then they can't be sent back. Wholesale retail bank products, including credit cards, which are just the normal retail operations, and we'll get to a little bit of that in a moment. Liabilities owed to an acquired subsidiary, and very importantly, qualified financial contract liabilities, and Tom is going to get into that in greater depth, a very important concept. Now, what's not assumed in terms of liabilities? Something which is not mentioned in the P&A agreement, which again can be, if we omit it, it's not assumed. A certain exhibit which talks about excluded contracts. Again, things which we don't know about exactly yet, and yet it's a defined term, and at some point we'll probably get them. Prior tax liabilities, because the FDIC takes them and uses them against as part of its own reporting purposes. Claims against the FDIC as receiver, so that if the FDIC has done something bad, you can't go against the acquiring banks, you go against the FDIC receiver, and you go through the claims process, and you get your magic receivership certificate. Liabilities for claims that the FDIC can make under the Dench-Doom doctrine, a very important doctrine that Tom is going to describe, and claims against the failed bank retained by the FDIC against receiver, so they can wash many claims through the receivership and not transfer them down to the acquiring bank. Next slide, please. In addition to specifically retained assets, the FDIC as receiver may also elect to retain or cause the acquiring bank to sell or transfer back the receivership. Quote, any acquired asset or asset essential to the receiver is determined by the receiver. In other words, anything they want to take back, they can take back. And this allows them, and this is what they're doing right now, they've got teams in the failed bank's offices going through records and deciding what it is they want to take back from the acquiring banks. And as I mentioned before, the acquiring banks also have got a more limited right to be able to purchase assets or to, from the receiver, or to send assets up or liabilities up to the receiver. So there's a process now in which people are finalizing what do they want to do and what is the resting place for many assets and liabilities. And if it's business as normal, you've got a high probability that you're not going to be involved in this. However, you could receive a notice from the FDIC or from the acquiring bank saying your asset or liability has been transferred and you now need to deal with a different party. And we're talking about investigation and assets that are subject to investigations, obligors that owe something to the FDIC from any institution. So the FDIC has got, frankly, super set-off power that they can utilize. So if you owe money to the FDIC from a former failed institution, they can take your assets and apply it. Anything secured by collateral, issues dealing with QFCs, and again, Tom will talk about that. Next slide, please. Within 30 days of the closing date, I mentioned the acquiring bank may purchase assets retained by the receivership, and it's got the right to put certain acquired assets back to the receivership. The P&A agreement has got very, very short timeframes in which the acquiring bank must go through this process. I think the maximum time frame, depending upon certain notifications, is 180 days. It's much less for assets and liabilities. But we have to be aware of these things, and we have to be aware, make sure that you open up any mail notifications or email notifications. If there's been a transfer out of the acquiring institution. And then again, then what you end up with is some level of stability, both in terms of the FDIC's receivership rights and those of the acquiring banks. Next slide, please. Under the P&A agreement, what is the acquiring bank obligated to do? Well, there's several things they need to do. The most important of all is that they're required to service all the assets and liabilities retained by the FDIC in the receivership. And this was a lesson learned in the last wave of failures of 2008 through 2010, because what it prevented the FDIC from having to do was to recreate the RTC and hire thousands of people and deal with all of the assets grabbed by the FDIC as a result of the S&L crisis. And it was just one giant chocolate mess. And that gets avoided by having the acquired bank doing this. They get paid for, and they're also retaining many of the employees of the failed banks. And so they've got a knowledge base of many of the things which they're going to have to be working on, even though they're now technically owned by the FDIC. They've got to provide full service banking in the failed banks assessment area. And this is kind of a reference to CRA assessment areas for 90 days. They can close branches within those areas. And they've also got the right to be able to purchase branches or to affirm or disaffirm leases in the branches. And they've got to operate credit card programs and most retail banking functions. And I'm going to give you the secret code in a moment. But just so you know, if they acquire the credit card operation, they do not have your rewards program is owned by the FDIC, and they don't have to continue it. They will have to provide the FDIC office space, and traditionally the FDIC will be on site for several months, and then they go off. I think they go off to Dallas or Houston, where their receivership headquarters is, and they begin to work there. They will retain employees for a period of time, and there's an obligation to pay them. And they've also got to maintain failed records. And that's very important because the FDIC, as they do their investigations, will use those records for the purpose of making claims against officers or directors, and probably the holding company in the case of Silicon Valley Bank's holding company for losses suffered by the FDIC. And now I'll turn the program over to my partner, Tom Kelly.
Hello. The worst of times, the FDIC holds your assets or your liabilities. As the two receiverships proceed, customers and third parties may receive a notice from the FDIC that the related assets or liabilities have not been transferred to the acquiring bank or have been reacquired by the FDIC. Where that happens, you get into the FDIC receivership regime, which is a very interesting regime, different than almost anything else under American law. The FDIC is lawmaker, litigant, judge, and jury. And so it is very difficult to win a case against the FDIC. You've got obstacles to getting into court. And if you get there, the law is very, very heavily tipped in their favor. There's no receivership court for an FDIC receivership. It's totally an administrative process. The FDIC's regulations govern the receivership. You've got a very limited right to administrative review or alternative dispute resolution review, and very limited rights to judicial review. Next slide, please. Joe mentioned some of the statements of policy that are out there from the 90s that arose primarily out of the S&L crisis, and to some extent are still valid. The statement of policy regarding the treatment of security interests is the most important to counterparties who have security arrangements with the FDIC. It's also now covered in 12 USC section 1821 E13A, which basically says that the FDIC will honor properly granted and perfected security interest in its assets. There's also a policy statement regarding qualified financial contracts, which has since been incorporated into statute at 18 USC section 1821 E8 through 11. A qualified financial contract we'll discuss later, but it's very similar to the bankruptcy law safe harbored contracts. Next slide, please. The FDIC's policy on the use of the receiver's common law and statutory defenses. This relates to the Dench-Dumey doctrine, which Joe referred to, and the related statute, section 1823E. And it really talks about how the two work together in light of an amendment to 1823E that was part of FDIC, which was the law that was passed in response to the S&L crisis. And I'll discuss that later. And then finally, the FDIC's anti-injunction law. This basically says you can't go to court and get an injunction to stop the FDIC from doing anything it wants to do in conducting the receivership. You go back afterwards and perhaps have judicial review for a claim, but most claims, as we will discuss in a minute, get paid nothing in an FDI receivership. Next slide, please. Finally, there's the policy on processing of deposit accounts in the event of an insured depository institution failure. This is what you would do if the FDIC ever let a bank fail and didn't end up guaranteeing all the deposits or selling all the deposits to an acquiring institution. It's probably never going to matter in light of recent government pronouncements. But nonetheless, if you ever find yourself in a receivership and you have deposit claims, this will be one of the things you look at. One of the things that that I noted on the FDIC's website is where you have securities accounts with the failed institution, you should be able to obtain title to your title to the securities that are being held, even if those assets remain in the receivership. That has not always been the FDIC's position, and may not remain their position in the future. But nonetheless, there is in this policy statement a reference to true securities accounts, not money market deposit accounts, but money market mutual funds held through the bank that are property of the customer and they should be able to get. Next slide. One of the key provisions in the FDI Act relating to receiverships is depositor priority. This was something that wasn't in place back in the 80s and was added in FDIC. And essentially it says that deposit claims have priority over all other unsecured claims against the failed bank. What that means is even those deposits that are above 250,000 are still going to get paid before other unsecured claims. And the result of that is reflected in this slide where we've outlined the returns to non-deposit creditors and select bank failures from 2008 to 2009. In the largest of those failures, Washington Mutual, there was a recovery to unsecured creditors of about 22.16%. But in 5 others, and I chose these 5 because they were cases that I knew something about, the recovery was 0 in all 5. So when you're dealing with an unsecured claim against the FDIC as receiver, the odds of your recovering anything are not great. Next slide, please. Now, why you may find yourself with an unsecured claim relates to the FDIC's power to repudiate loans, leases, and other contracts. And the FDIC has the right to either repudiate a third-party contract or lease or affirm it. And in a situation like the two bank failures that we're addressing today, the ones that are going to be affirmed are the ones that are going to be transferred to the acquiring bank, and anything that's left behind is probably going to be repudiated. So what does that mean? If you're a lessor to the failed bank and the lease is repudiated, you will get payment of rent through the date of repudiation and nothing more. Where branches are taken over by the acquiring bank, you won't have to worry about this, but if they're not, this is where you'll end up. For most contracts, you only get payment for services rendered through the date of repudiation, and that's the only claim you have for damages. Letters of credit are interesting because the FDIC, or lines of credit are interesting because the FDIC generally does not lend under outstanding lines of credit that are in a receivership. They may make exceptions for collateral protection and for certain emergency situations, which are not defined. But the acquiring banks will be lending under the lines of credit that they've assumed. So for most borrowers from these two failed banks, they're going to be able to continue their banking relationships. And the only instances I'm aware of where borrowers that I was involved with had a line of credit with SVB, they were able to continue borrowing. Next slide, please. Letters of credit will be repudiated unless they're assumed by the purchasing bank, which in the case of these two receiverships, they were. But beyond that, the FDIC treats repudiated standby letters of credit as contingent obligations, which means there's no claim that's provable in a receivership. Now, you can fight that, and there are courts that have disagreed, but in the end, you're probably going to end up either with nothing if the FDIC's position is upheld, or nothing if you get an unsecured claim against the receivership. Fortunately, with the acquiring banks in these cases honoring letters of credit, that shouldn't be a problem. Next slide, please. Now we get to QFCs, qualified financial contracts. The term is defined as meaning any securities contract, commodity contract, forward contract, repurchase agreement, swap agreement, or any similar agreement that the FDIC determines by regulation or resolution to be a QFC. The current regulation on this is at 12 CFR section 360.5, and pretty much matches what's in the statute. The definitions of these types of contracts are somewhat different than the corresponding definitions in the bankruptcy code, where all these types of contracts get safe harbor treatment, but it's basically the same types of agreements. And QFCs are generally always assumed by the purchasing bank, and that's the case with SVB and Signature Bank. So if you have a QFC with one of the failed banks, you're not going to have a problem in continuing to operate under it. If the QFC is ever left behind in the receivership, the statute provides that the counterparty is entitled to enforce its remedies with respect to that contract. That means you can exercise netting remedies, you can exercise remedies with respect to collateral, and you can terminate the agreement and get a calculation of the final amount owed. To the extent you're left with an unsecured claim at the end of that, though, you're back in the same land we talked about before, which is not recovering much of anything, if anything. Next slide, please. There are specific provisions, both in law and in the regulations, that deal with participation agreements. And the agreements we're talking about here primarily are agreements where the failed bank was the lender under a loan agreement and then sold participations to other banks or other third parties as part of its management of its assets and liabilities. And the FDIC's ability to repudiate a participation agreement and claw back the participation is very limited. The FDIC as receiver cannot disaffirm or repudiate participation contracts or reclaim, recover, or recharacterize transfer made under a participation contract as long as that contract would get accounting treatment as a true sale, other than satisfaction of the legal isolation condition, which is essentially the legal true sale characterization. I do not know, because I was unable to find, of any situations where a participation that failed to satisfy the legal isolation condition constituting a true participation under applicable non-receivership law was nonetheless honored by the FDIC. That doesn't mean it hasn't happened, but I think the way you should look at this is if you've got a participation with the FDIC and it's a true participation, which means that you have a pro rata right to receive payments. They do also have a provision that protects last out participations. I don't mean to avoid that, but if you've got a true participation where you got a pro rata participation in payments made and in the obligation to lend under a loan, and there's no recourse to the originator, so that you're not in a situation where the transaction would be recharacterized as a loan by the participant to the originating lender, then you should be good here. Other than the fact that the originating bank has failed and all of the participants' rights run through the originating bank. Now, the FDIC as receiver will have all the incentive in the world to collect on that loan, but they may not otherwise act as a bank looking to preserve a relationship, but instead may be more aggressive and as a result recover less. Securitizations are also covered by the safe harbors. And here there's an express, again, exception for the legal isolation or true sale requirement. But you have to satisfy the alternative regulatory requirements in 12 CFR 360.6 if you don't satisfy the true sale requirement. Pretty much securitizations are honored in the receivership unless there are other issues. And those other issues, next slide, please, are essentially things that the FDIC has the power to avoid, and that fall into two categories. And the first of those categories is the Dench-Dumey doctrine and the related statute, which is on the next slide. Dench-Dumey was a case where they voided an unrecorded scheme or arrangement that would mislead banking authorities concerning the assets and liabilities of the failed bank. This was a situation where the third party Dench-Dumey entered into an understanding with the president of the bank that they were in fact going to get paid a certain amount, but it was never put into the records of the bank, and therefore the bank regulators were unaware of it. And the bank regulators, the FDIC argued successfully up to the Supreme Court that because it was not part of the books and records of the bank, it shouldn't be enforceable against the bank, even if it would be an enforceable contract under state contract law. And they won. So basically, the effect of Dench Dumi is that if there's a loan or contract modification that should have been on the books of the failed bank, the FDIC doesn't have to prove fraud or any intent. It can simply avoid the obligation under the Dench-Dumi doctrine, as it's called. And the rationale is that it protects the integrity of the bank examination function. Next slide, please. No, back one. Back, yeah, this one. The Dench-Dumi doctrine was codified in 1950, so 6 years after the decision, or 8 years after the decision, in 12 U.S.C. section 1823E, which, as it's been amended, provides that to be enforceable against the FDIC as receiver, an agreement must be in writing, executed by the failed bank and the person claiming an adverse interest, contemporaneously with the bank's acquisition of the asset. But there are statutory and regulatory exceptions for that. I'll talk about that in a minute. Has to be approved by the board of directors of the failed bank or its loan committee, and it must have been continuously from the time of execution an official record of the failed bank. Operationally, it's very difficult to comply with this in a lot of circumstances. Loan agreements get amended, and banks take collateral for loans after the loan is originated, and banks will sometimes agree to change the terms of a loan in a way that's beneficial to the borrower as part of a workout arrangement. All of those kinds of changes are covered by the regulatory and statutory exceptions. And the FDIC's application of 1823E reflects this in terms of, you know, they're looking for situations where there was something inherently wrong with the transaction, not for a technical violation. Now, 1823E, as initially adopted, was both broader and narrower than Dench-Dumi. Back in the late 80s and early 90s, when we were under the pre-FIREA regime, I did a bunch of work for Brian Palmer, who was then a partner in our banking department, who represented the FDIC in a number of bank failures in the upper Midwest. And the FDIC would have us argue both 1823E and Dench-Dumi in the same cases. But in the policy statement that's referred to at the front end, they basically said, after the FIREA amendments, they no longer thought there was any difference between the two, and so they would not pursue Dench-Dumi if something satisfied 1823, but of course reserving the right to change their mind. So bottom line is that if you've got a claim that gets tied up with 1823, or if you have a loan that gets tied up with 1823E, the FDIC is in a position to try and void that loan or void whatever rights you think you have under an agreement that doesn't satisfy those requirements. One more page. Fraudulent transfers. The FDIC has its own fraudulent transfer provision. And that provision essentially is an intentional fraudulent transfer provision. It says that any transaction that was made within 5 years of the date on which the bank failed, and it was made with the intent to hinder, delay, or defraud the FDIC or other federal banking agency, can be avoided. Now, this is generally applied to transfers involving institution affiliated parties. It's not generally applied to genuine third-party transactions. And there's no equivalent in the FDIC statute for a constructive fraudulent transfer under either the bankruptcy code or state fraudulent transfer laws. That's a transaction where the transferring party did not receive reasonably equivalent value. It was made at the time that the transferring party was insolvent. That does not end up in being an issue in an FDIC receivership unless they can somehow take advantage of the state fraudulent transfer laws. And so the bottom line is that if you don't end up in one of the protected categories of assets, which are not insubstantial, you may find yourself with a unsecured claim in the receivership with a value that has a nice round number. So unless Joe or Aaron, you have anything to add, I think that brings us to conclusion.
That's great, Tom. Thank you very much. Let's
Right, well,
see, next slide, please. Thanks for attending. This slide explains how you can get credit. We ask you to please contact either any of us or your regular Dorsey contact if you have questions. There are a lot of things which are going to continue, such as the claims procedure, which we have not even gotten to, and that's going to be taking place down the line. This is going to be posted on our website, and Aaron mentioned the fact that we've now got a resource page for you, and it will be updated as information continues to leak out slowly but surely from the FDIC and the receiverships. Thank you all very, very much today for attending, and have a pleasant rest of the afternoon.